Hi, everyone. Welcome. Thank you for joining us. My name is James Crayton. I'm a partner and head of the commercial team at Walker Morris, and I also lead the manufacturing sector. I'm joined here today by my colleague, Nick Lees, who's a partner in our commercial disputes team. And we want to talk to you today about some of the issues around disputes in complex commercial arrangements for manufacturers. So we're talking about things like getting your product to market, distribution, agency, and logistics, and also just those big complex partnering type arrangements that come around maybe once every 10 years or so for businesses where it's a really kind of important and complex partnership. We're going to talk about particularly the differences between litigation and arbitration and the things that you can do in advance of a dispute when you're negotiating the contract to put yourself in the best position to deal with an issue if it does arise down the line. We know that we hope never to have a dispute. We hope that when we sign the contract, everything's going to be rosy and you're never going to fall out. But sometimes there are those issues that arise, and we think it's worth thinking up front about how you might deal with those issues, and that puts you in a better position should the worst happen. So, Nick, can we start with the basics? What is the difference between arbitration and litigation?
Sure. Yeah. So litigation's going to court, and any substantial business dispute, which is what we're talking about here, will be dealt with in the business and property courts, where we have sophisticated judges who are used to dealing with commercial matters, with business disputes. Arbitration's closely related to litigation, but there are some key differences. Arbitration takes place in private, in a conference room. Litigation takes place in public, in a courtroom. And just to say up front, you have to choose between arbitration and litigation. It's one or the other. You can't agree to do both, because essentially the parties are agreeing to oust the jurisdiction of the court by agreement. And once they've agreed to do that, one party can't then change its mind later on once a dispute has arisen. The bones of the process, of the arbitration process, are similar to litigation. It follows that path of having a round of written argument and pleading, setting out the facts and the law, followed by exchanges of evidence, normally electronic information these days, emails and what have you, written statements from witnesses, expert reports, and then a final hearing, which is like a trial in court, at which the arbitrators will make a final award. So we call it an award rather than a judgment when you're in arbitration. So it's similar, process is similar, but arbitration can be more flexible than litigation in court. In court, there's a rigid set of rules, a civil procedure rules that we have to follow, and a set process that a dispute moves through. In arbitration, the process is not so rigid. You can start with a blank sheet of paper for each case, and the process can be changed depending on what's agreed between the parties and what's required. So you can do things to speed up the process and save costs. So it might be that you agree that it's cost effective to dispense with a full disclosure of documents exercise, which is something that can take up a lot of time or a lot of money. Other features of arbitration are that you decide the geographical location where it takes place, which can be important in a cross-border situation with parties, different nationalities, and the language it'll be conducted in. And there's flexibility in being able to choose your arbitrators. So if you're operating in a specialist sector, you might want arbitrators who've got deep knowledge in that sector. So I said before, it's a confidential process. Arbitration is heard in private, as I said. The only parties that can be involved are the parties themselves, their legal teams and advisors, and the arbitrators. And that's not the case with litigation, where anybody can come into a courtroom and observe a trial. And also the public can get access, quite extensive access to information from the court files. There's a lot of publicly available information. Yeah. So privacy is a very important reason for parties choosing arbitration if they don't want to air their grievances in public or have judgments published to the world at large about their business affairs. Arbitration is solely a creature of contract. It arises as a result of a contractual agreement between the parties. So you can't commence an arbitration against a party who hasn't agreed to arbitrate with you. And that's why when you're drafting contracts, if the client wants to use arbitration, you're putting the arbitration agreement into the main contract.
Yeah.
And I should say that an arbitration agreement, an agreement to arbitrate, it can be made at any time. But, the reality is that after a dispute's arisen, it can be hard when relationships are not so good to get people to reach agreement to use arbitration.
Yeah, the horse is probably bolted at that stage, hasn't it? So thinking ahead then, when you're negotiating the contract, if you think arbitration is going to be useful for your relationship, what are the things that you're thinking about when you're putting that arbitration agreement into the contract? What do you want to cover? What are the options that you can address there?
Yeah. So the contract will have a governing law clause, which will be English law when we're involved. And that's the substantive law of the contract. With arbitration, you also have to think about the seat of the arbitration. And what the seat does, it gives the arbitration its own nationality. Right. So popular seats for arbitration are England, France, Singapore, Dubai, Switzerland, Hong Kong, USA. So just to bring that to life, you can have an English arbitration taking place in Singapore.
Yeah.
And in that example, the arbitration would be Singaporean. So the award would be Singaporean, even though you've got English law arbitrators deciding questions of English law. And the seat's important because it dictates the national domestic laws of the courts that support the arbitration. So if you want to go to court to get some support for an arbitration, maybe to preserve assets pending the outcome of the arbitration, or to go through a process of removing an unsuitable arbitrator, you're then relying on the local courts and their legal powers under the laws of that state. So the seat should always be a country which is tried and tested for arbitration, is familiar with arbitration, and is an arbitration-friendly jurisdiction. And in that way that we've just been talking about, arbitration can cross national borders with a lot more ease than English litigation. And that can be an important consideration when you're dealing with international business relationships. When you're negotiating contracts with parties from different countries and cultures, each party might not want vital commercial matters decided in the national court of the other party. They might want more neutrality in the interests of independence, interests of fairness. So arbitration can be a fair compromise that leaves both parties feeling that they've agreed to an independent and fair, neutral, well-tried forum for resolving substantial commercial disputes. So I guess examples of that we've seen German companies supplying complex engineered products to port facilities in West Africa, where the documents have been English law documents with an English seated arbitration. We've also seen our US clients supplying complex equipment into Saudi with English law contracts, but with a Swiss seated arbitration for the kind of neutrality that goes with that. So these can be important considerations. Arbitration can give you options like that you don't have in litigation. And enforcement is important. So let's just talk briefly about enforcement. So this is where you win a case and the other party, the losing party, doesn't voluntarily pay the monies that are due under the arbitral award. Then you have to take steps to enforce that award. And you'll be doing that in the country where the losing party has assets that you want to enforce against. A court order from an English court is not recognised in another jurisdiction without taking steps. You've got to take steps to get the English court judgment recognised in the foreign country. And that can become very complicated because it depends on the laws of the other country, whether they recognise English court judgments and respect them. With arbitration, the arbitrators have made the award saying how much money has to be paid, but the arbitrators themselves, they can't force compliance because they don't have the inherent legal power of the judiciary. They're private decision makers. So you take the arbitral award to the local court and you apply for a court order to enforce it. So essentially what you're doing is you're asking the courts where the judgment debtor is based to recognise the arbitral award. And internationally, arbitration awards are widely recognised and widely enforceable. And that's due to an international convention called the New York Convention from 1958, which I'm sure you've heard of. People talk about it a lot. more than 145 states have ratified that. So it's going to be more efficient to enforce an arbitral award internationally often than it is an English court judgment.
It's interesting. And I've seen various bodies, the kind of arbitral bodies nominated in contracts, and some of the names familiar with International Chamber of Commerce, London Court of International Arbitration. It's calling itself a court, but from what you said, it's not a court. So they are private, sort of non-judicial entities. Is that right?
That's right. No, that's exactly right. So they are arbitral institutions, and you've just mentioned two of the most prominent: ICC, LCIA. And what they do is arbitrations are conducted under the rules of those established arbitral institutions. They have their own procedural rules, similar to the civil procedure rules, but shorter, lighter. Right. And what's also important is that those arbitral institutions have quite a sophisticated administration function to support arbitrations and help with the appointment of the tribunal in the first place. If you're not doing institutional arbitration, we call it, the alternative is ad hoc arbitration, where you're going it alone without the support of an institution, without a set of rules for the parties to use. So you're doing everything from scratch. And my own view, you probably won't be surprised to hear, is that for complex contractual disputes that we're talking about here, it's better to have institutional arbitration. You've got clear, comprehensive rules that are tried and tested for progressing and bringing disputes to a conclusion. And you can get the arbitration up and running with help from the institution, where, sometimes you've reached a point where the parties are at the stage where they can't even agree on who to appoint as the arbitrator.
Yeah, I can see how sort of there's you're losing some of the advantage almost of the arbitration if you go ad hoc, because you're then having to sort of come up with more of the process yourself potentially, whereas you can rely on the kind of efficiency and established systems of the rules of the arbitral body if you're appointing someone like LCIA. And so they're non-judicial. And I know that in a kind of litigation context, you would be potentially, you get to the end of the litigation and you say, well, we're going to appeal it. There's grounds to appeal. Can you do the same in arbitration? Have you got the same sort of layers of appeal in arbitration?
That's a good question. And the answer is no. It's much harder to appeal an award. Generally, the decision of the arbitrator is final and binding, and the grounds of appeal are very, very limited, very, very restricted. And that's one of the features of arbitration. It's the finality that parties avoid. Protracted appeal processes running on for many years. And I suppose that can cut both ways. It can be a benefit or not, but it is one of the features of arbitration.
Yeah, it's interesting. It if you're on the losing side of it, you might regret it, but actually it gives both parties, winner and loser, the clarity and the finality that that's it. It's not going to drag on, for years and decades, that you can see sort of very complex litigation go through. So look, I'm getting that the advantages of arbitration are things like international enforceability. Sounds like that's actually quite a big advantage. It's flexibility. You can sculpt it in the way that works best for you in the commercial relationship you're creating. And then confidentiality seems like a really big advantage. These are, we're talking about the complex transactions where there is probably quite a lot of sensitive commercial and technical, potentially, information involved. So shielding that in a private arbitration sounds like a very, very advantageous thing in some circumstances. And then finality, the kind of the lack of a layer upon layer of appeals. In some circumstances, that's probably a really big advantage, that you've got the certainty there as well. We talked at the beginning about this is, where the context we've got here is the most complex disputes. Some of the most complex disputes and most complex commercial relationships will be ones where there are lots of parties, multi-parties. It's not just a kind of A plus B coming together. There's lots of chains and interrelationships. How does arbitration cope with that? Is that something that arbitration is adept to deal with as well?
Yeah, so I suppose in your work, you're dealing with complex commercial arrangements that are often documented through a chain of different contracts with different parties. And our clients don't know until it happens, what the dispute will be about and which contract it might arise under, which parties will be concerned. From my point of view, when something goes wrong and clients have to go into a formal dispute resolution process to drive a dispute to conclusion, It's not a good position to be in to have multiple overlapping dispute resolution processes, because that can lead to the risk of inconsistent decisions. And it can also be very cumbersome and really very expensive to have to run different processes against different parties relating to different contracts. It's much better, much more efficient to have matters determined by the same tribunal in a single set of proceedings. So in litigation, in court, the law allows any number of claimants and defendants and any number of claims generally to be dealt with in one set of legal proceedings. The legal test is whether all the claims can be conveniently disposed of in the same set of proceedings. So the inherent legal power of the court is very beneficial in these complex multi-party situations that you're talking about, because you can bring a lot of parties, a lot of different contracts into one piece of litigation. But we spent time today talking about the benefits of arbitration. Some clients might want to use arbitration for the benefits, rather than litigation. The confidentiality that you're talking about, maybe because of the international nature of arbitration. So if a client wants to use arbitration in multi-party deals with multiple contracts, needs some careful planning and preparation at the outset when you're pulling the deal together, pulling the project together and then preparing the documents. And it flows back around to what we were talking about before, which is that arbitration's based on the consent of the parties to arbitrate, rather than leaving the courts to resolve disputes. If you've got interrelated contracts and you want to arbitrate, they should contain the same form of arbitration agreement.
Consistent.
That's it, the same seat, same institution. So you're mirroring the arbitration clauses through each of the agreements. And if it can be negotiated, express agreement reached and recorded that disputes under different contracts can be consolidated, and transaction parties will consent to being joined into other arbitrations relating to the same subject matter. So all that has to be provided for. It doesn't happen automatically under the powers of the court. So it takes more planning and preparation and agreement when you're constructing the deal. And if you're not doing that at the point of contracting, it's very unlikely to be agreed once the dispute has arisen and the parties have fallen out. So what I've just described, it can be very clunky when you're preparing a lot of different contracts, negotiating with different people, working on a series of contracts. So another option, if it's possible, if you can achieve it, is to have an umbrella agreement dealing with disputes only. So setting out what mechanism will be used, all parties involved in the project or the transaction agreeing to use arbitration, if that's what you're going to do, and covering the things that we've been discussing in this session. And then you can take that umbrella agreement and incorporate it into each of the contracts that are making up the project or deal that you're working on.
And that's certainly something that we see on complex multi-party and multi-contract projects, where you would put an umbrella agreement in place to kind of govern any issues that arise across them, and the efficiency of doing that in one document can actually be quite an advantage. So, look, Nick, thank you. That's really, really been interesting to me, hopefully to people watching as well. I think there's a lot of takeaways there. The main one I would say is that thinking about this up front is a lot easier than doing it further down the line when you may have already fallen out, and the chance of getting something nice and efficient and consensual agreed is seriously diminished. There are some big advantages, that the confidentiality, the international enforceability, even the finality, I think, are things that will be, in some circumstances, very attractive to commercial parties. The multi-party element that we've just talked about, clearly that is something where litigation might have innate advantage, that the courts have got those powers to pull parties together to resolve, but you can overcome it with some careful drafting and some thought up front to corral parties in those more complex projects together. So thank you very much for watching today. Hopefully you found it interesting. This will be featured on our Factory of the Future website, which I will give a little plug to. There's loads of resources on this and other related issues for manufacturing businesses on the Factory of the Future website. So please check it out. and thank you for joining us today. Cheers.